Order in the courtroom. Judge Anthony Triner's voice boomed through the crowded federal chamber as he brought his gavel down with force. The sharp crack bounced off the polished wood panels while everyone turned toward the tense standoff unfolding in front of them. Judge Triner leaned forward, his expression tight with irritation, and aimed a pointed finger at Congresswoman Jasmine Crockett. "I will not tolerate this behavior in my courtroom, Congresswoman," he said. Each word dipped in unmistakable scorn for nearly 10 straight minutes. He had been publicly chastising her over courtroom protocol after she attempted to introduce fresh evidence in a major civil rights lawsuit. The crowd inside the gallery watched with wide eyes as one of Virginia's most influential federal judges continued his harsh reprimand of the Congresswoman. "Congresswoman, regardless of your office, the rules of evidence apply to every person in this courtroom," Judge Triner continued, his tone dripping with superiority. "Your attempt to submit these documents at this stage shows a basic misunderstanding of federal procedure." People in the gallery shifted uncomfortably. A few journalists traded glances, realizing they were witnessing something very unusual, a federal judge openly berating a sitting member of Congress, who had once been a practicing attorney herself. What followed stunned Judge Triner and sent shockwaves through the legal world. Crockett quietly opened a leather portfolio, revealing documents no one expected, papers that would not only flip the entire case on its head, but also raise serious questions about Judge Triner's own judicial conduct. If you're tired of watching powerful figures misuse their authority, you'll want to see what comes next. Hit that like button and subscribe, because what Congresswoman Crockett did next didn't just strengthen her case, it exposed a level of judicial misconduct that experts will be debating for years. To understand why this explosive courtroom moment is sending tremors through America's legal community, we need to take a closer look at who these two figures are and why their clash means far more than a heated exchange in front of a judge. Judge Anthony Triner, now 71, has served on the U.S. District Court for the Eastern District of Virginia since 2008 after being appointed by President George W. Bush, armed with a Georgetown law degree and a background at one of Virginia's elite law firms. Triner built a reputation as a strict, no-nonsense judge known for tight control over his court, well known for his conservative legal views. He rose to national prominence while overseeing several major national security cases. Within the legal world, he is generally respected for his attention to procedure, though many attorneys quietly note his tendency to reprimand lawyers he believes are unprepared. Over the years, he has developed strong ties to corporate interests and conservative legal groups, frequently appearing at their conferences and events. The civil rights case at the center of this confrontation involved accusations that a major corporation had discriminated against minority employees in hiring, promotions, and workplace treatment. The plaintiffs had uncovered damaging evidence that survived multiple legal attempts by the corporation's lawyers to shut the case down. Recently, Judge Triner had grown increasingly skeptical toward the plaintiffs' arguments, issuing rulings that severely restricted the scope of evidence they could introduce. Legal observers whispered concerns about possible bias. Though few were willing to openly criticize a sitting federal judge, Congresswoman Jasmine Crockett arrived in this courtroom with a sharply different background. Serving her second term in Congress from Texas, she had quickly built a reputation as one of the sharpest former attorneys in Washington. Before entering Congress, she spent 15 years as a civil rights lawyer and criminal defense attorney. A graduate of the University of Houston Law Center, Crockett earned recognition for taking on corporate discrimination cases and defending communities whose civil rights had been trampled. Known for her thorough preparation and creative legal strategies, she frequently caught opposing lawyers by surprise. What many didn't realize was that Crockett still maintained her legal license and occasionally represented clients in major civil rights cases, like this one, where she had recently joined the legal team on behalf of the plaintiffs. The confrontation became inevitable when her team attempted to introduce newly uncovered documents, showing a pattern of discriminatory behavior across several corporate locations. Judge Triner denied the motion on timing grounds, a decision that could have devastated the plaintiff's ability to prove systemic discrimination. When Crockett stood to speak that morning, most expected standard arguments about admissibility. No one imagined she had spent the past 3 weeks running her own independent investigation, an effort that uncovered not only powerful evidence for the case, but also information about Judge Treanor himself. Information that would threaten to reshape his entire judicial reputation. If you're finding this coverage helpful, make sure to tap that like button and subscribe to the channel. We break down major moments inside America's justice system, events the mainstream outlets often ignore. Your engagement helps us continue bringing you these deep, essential analyses. That Thursday morning, the United States District Court for the Eastern District of Virginia was unusually full. Extra seating had been added along the walls to make room for the surge of spectators, many of them law students from nearby campuses who came specifically to watch Congresswoman Jasmine Crockett argue the motion. The courtroom carried the familiar solemn atmosphere of a federal setting. Polished wooden benches, the large emblem of the judiciary mounted behind the judge's bench, and the elevated platform where Judge Treanor would preside. When the bailiff announced his entrance, Judge Treanor stepped in wearing his black robe, scanning the packed room with a firm, controlled expression. We are here to address the plaintiff's request to reconsider the ruling regarding recently uncovered evidence. Judge Treanor began, his voice already carrying an edge of doubt. I will note that it is somewhat unusual that Congresswoman Crockett has chosen to argue this motion herself rather than allowing lead counsel to do so. Thank you, Your Honor, Crockett replied as she rose from the plaintiff's table. Dressed in a sharp navy suit, she projected calm confidence. I appreciate the court taking the time to review this important matter. Over the next 10 minutes, Crockett laid out her legal argument piece by piece, explaining the basis for admitting the new evidence. She referenced the federal rules of civil procedure and relevant case law with impressive accuracy. Those familiar with the law immediately noticed she wasn't reading from notes. She recited case names, dates, and legal standards entirely from memory. Judge Treanor interrupted repeatedly, his remarks growing more pointed. Congresswoman, I am familiar with the Foreman decision, but it does not apply here, he said sharply. Your team had more than enough time during discovery to locate this material. The rules exist for consistency and fairness. We cannot allow parties to introduce new information every time they find something late. With respect, Your Honor, Crockett responded steadily. The Foreman decision deals directly with situations where the opposing party intentionally withholds evidence. That is exactly the situation we have here. She stepped toward the bench and opened a folder. This email chain shows that defense counsel was aware of these documents 8 months ago and failed to produce them even after we issued a direct discovery request. Judge Treanor studied the emails briefly. His expression darkened. This is concerning, he admitted, but it does not change the fact that your motion falls outside the timeline set in our scheduling order. That's where the Rodriguez standard is relevant. Your Honor, Crockett replied immediately. When a party discovers discovery violations after a deadline has passed, the court has the authority to modify its scheduling order in the interest of fairness. Those seated in the courtroom could feel the tension rising. Legal observers knew exactly what Crockett was doing. She was cornering the judge using his own logic and past rulings. Her mastery of procedural rules made it difficult for him to dismiss her arguments. Congresswoman Crockett, Judge Treanor said, shifting into a patronizing tone, while your advocacy is admirable, I believe you may be out of your depth when it comes to federal procedure. This is not a congressional hearing where the rules can shift for dramatic purposes. My courtroom follows strict procedural traditions developed over generations of legal practice. The condescension was impossible to miss. Several students exchanged uneasy glances. Crockett remained poised, though she lifted her chin slightly in response. Your Honor, she said calmly, before I entered Congress, I litigated over 100 federal cases, including 8 before the Fifth Circuit Court of Appeals. I am fully familiar with federal rules. And with all due respect, The rule you're citing does not say what you have just stated. The courtroom fell silent. It was extremely rare for any attorney, let alone a member of Congress, to correct a federal judge so directly. Judge Trainor's cheeks flushed. "Then please explain it to me, Congresswoman," he replied, the sarcasm cutting. "Gladly, Your Honor." Crockett returned to the bench with another folder. Federal Rule of Civil Procedure 60, B. 2 allows reconsideration when new evidence is discovered that could not have been found earlier with reasonable diligence. The important phrase is reasonable diligence, which you're ruling in United States v. Davidson, defined as efforts appropriate to the circumstances and limitations faced by the party. She placed a printed copy of Judge Trainor's own Davidson ruling on the bench. "Your Honor, this is your opinion from last year. Our team exercised every reasonable effort to uncover this information, but the defendants intentionally hid these documents, exactly as the emails I provided show." Judge Trainor read over his own words. Clearly unsettled by having his previous ruling turned directly against him, the audience watched closely as he shifted in his chair, visibly rethinking his position. "Even if I were to accept that argument, Congresswoman," he said slowly, "the evidence must still be material to this particular case. Complaints from employees in other states do not automatically prove a pattern relevant to plaintiffs in Virginia." This was the moment Crockett had been waiting for regarding materiality. "Your Honor," she replied, "I'd like to present one final document that proves these complaints are directly connected to this case." She reached for a third folder. "This is an internal memo sent from the corporation's HR director to their general counsel on January 12th of last year." As she passed the memo forward, she continued, "It explains the company's efforts to keep complaint handling uniform across every state, specifically to avoid creating records that could reveal a nationwide pattern of discrimination." She pointed to several highlighted sections. "This memo references all 7 states where identical issues were reported, including the same concerns raised by our plaintiffs here." Judge Trainor read the memo, and his expression grew more troubled by the second. "Where did you obtain this memo, Congresswoman?" "It wasn't included with your original motion." "It came into our possession last night, Your Honor," Crockett replied. "A whistleblower from the corporation's legal department reached out after learning that you had denied our first request." She paused, letting the statement settle. "The whistleblower said company attorneys were confident they would receive a favorable ruling from you before you even heard our arguments." A wave of shocked whispers swept through the courtroom. Judge Trainor slammed his gavel. "Order! The court will have order. Congresswoman, comments like that border on contempt." "I'm not making accusations, Your Honor," Crockett said firmly. "I am presenting documented facts." She walked back to her table and picked up yet another folder. "And this leads me to the most troubling document of all." The entire courtroom focused on her as she approached the bench with the final piece of evidence. Defense attorneys sat frozen, exchanging nervous looks, while spectators leaned forward in anticipation. "Your Honor, this document also came from the whistleblower," Crockett said, her tone steady. "It is an email exchange between the lead defense counsel and the corporation's CEO discussing their litigation strategy." She handed it to the clerk, who delivered it to Judge Trainor. As he scanned the text, his face drained of color. "The email states, this is a direct quote," she said. "Judge Trainor has been reliable in these matters since his appointment. His former law firm continues to represent our subsidiary companies in 3 states, and his public financial disclosures confirm that he still holds investments in our parent company. We can depend on him to reject cross-state evidence on procedural grounds." The room fell silent. The implications were enormous. Conflict of interest, possible bias, and potential judicial misconduct. Judge Trainor's hands shook as he set the document aside. "Congresswoman, these are extremely serious allegations. They have no bearing on whether your evidence is admissible." "With respect, Your Honor, they are directly relevant," Crockett answered. "Federal law requires judges to recuse themselves if they have any financial interest, no matter how small a corporation involved in the case." She lifted another document. Your publicly filed financial disclosure forms show investments in Transcorp Holdings, the parent company of the defendant. She placed the copies on the bench. Furthermore, under 28 U.S.C. Section 455, recusal is mandatory when a judge's impartiality could reasonably be questioned. The fact that your former law firm still represents the defendant's subsidiaries is exactly the type of conflict the law addresses. Suddenly, the defense attorneys jumped from their seats. Your Honor, we object. This is an ambush. It has nothing to do with the motion before the court. On the contrary, Crockett spoke up before Judge Traynor could even respond. It has everything to do with it, she said firmly. She explained that the legal standard for reconsidering a ruling includes whether justice requires the court to revisit an earlier decision, and when that decision was made by a judge who never revealed major conflicts of interest, justice doesn't just allow reconsideration, justice demands it. Not only for this motion, she argued, but for every ruling the judge had issued in the entire case. Judge Traynor looked completely shaken. The confident attitude he entered with had vanished. The courtroom fell silent as he sat there, clearly struggling to figure out his next move. After what felt like forever, he finally spoke. This court will take a 30-minute recess. I need to consult with the chief judge. Without another word, he stood and hurried back into his chambers. During the break, the courtroom erupted into stunned whispers. Law students scribbled notes as fast as they could, and reporters rushed to publish breaking updates. Several veteran attorneys in the gallery were overheard saying they had never witnessed anything remotely like this in decades of practicing law. When Judge Traynor finally returned, his expression was somber. Walking beside him was Chief Judge Rebecca Hollis of the Eastern District of Virginia, a widely respected judge known nationwide for her strict commitment to judicial ethics. Judge Traynor's tone was subdued as he spoke. In light of the matters raised today, I am recusing myself effective immediately. Chief Judge Hollis will address the court. Judge Hollis stepped forward. This court takes allegations of judicial misconduct and undisclosed conflicts with the utmost seriousness, she declared. She told the courtroom that she would personally review all evidence that had been presented and had already notified the Judicial Council of the Fourth Circuit to begin an ethics investigation. Turning to Crockett, she said, Congresswoman, your motion to admit the new evidence is granted. Additionally, I am ordering a full review of every previous ruling in this case. This matter will be reassigned to Judge Williams, who has no connections to any party involved. As Crockett collected her documents, everyone in the courtroom understood exactly how significant this moment was. What had started as a routine procedural motion had suddenly exposed major ethical violations that could permanently damage Judge Traynor's career and affect countless past rulings he had issued. Outside the courtroom, reporters swarmed Crockett. She stayed calm and professional. This was never about a personal dispute, she said. It was about making sure our judicial system is fair to everyone, no matter their wealth or influence. When the rules apply equally, justice is possible. The fallout from the Crockett-Traynor confrontation spread quickly. By that evening, the story was headline news across the country. The Washington Post published the headline, Congresswoman uncovers federal judges' hidden conflicts in dramatic courtroom clash. CNN hosted a panel of legal experts to analyze the national implications for judicial ethics. Within 48 hours, the Judicial Council of the Fourth Circuit announced a formal investigation into Judge Traynor's financial disclosures and potential conflicts in dozens of cases he handled over the last 5 years. The House Judiciary Committee also opened an inquiry into whether other federal judges might be hiding similar conflicts. For Judge Traynor, the consequences were immediate. He took an indefinite leave of absence while the investigations moved forward, and court filings showed he had begun removing himself from every case involving companies connected to his investments or former law firm, more than 30. Pending cases in total. Legal experts across the political spectrum weighed in. Harvard law professor Lawrence Friedman wrote in a viral op-ed, Congresswoman Crockett's work goes far beyond a single courtroom win. She has revealed a dangerous gap in our nation's system for enforcing judicial ethics. Even conservative former federal judge William Pryor acknowledged on Fox News, "I disagree with Representative Crockett's politics. But what she did in that courtroom was a textbook example of true legal advocacy. Conflict of interest rules matter, and they apply no matter who appointed the judge." 2 weeks later, the whistleblower who supplied the evidence came forward, Melissa Shan, a paralegal at the defendant corporation. She told reporters, "When I heard company lawyers bragging about their influence over Judge Traynor, I knew I couldn't stay quiet. This wasn't political. It was simply the right thing to do." For the plaintiffs in the original discrimination case, the impact was life-changing under Judge Williams. The newly admitted evidence was reviewed in full, revealing a clear and detailed pattern of long-term discrimination inside the company. Within just 3 months, the corporation agreed to a landmark settlement of $175 million and accepted strict, court-supervised reforms to its hiring and promotion systems across all departments. Crockett's courtroom win quickly became recognized as a precedent-setting moment with national impact that reached far beyond this single lawsuit. Soon after the ruling, the Administrative Office of the U.S. Courts introduced tougher rules for judicial financial disclosures and mandatory conflict of interest checks. Several federal judicial conferences added special training sessions on ethics, focusing specifically on investment-related conflicts. Law schools across the country updated their ethics courses to include the Crockett-Traynor confrontation as a model case study. Georgetown Law even launched a new seminar titled Advocacy and Ethics When Challenging Judicial Conduct Becomes Necessary. The American Bar Association followed by revising its guidelines to clarify what attorneys must do when they suspect a judge may be influenced by financial or professional conflicts. For Congresswoman Crockett, the incident reshaped her national reputation. While she had long been respected for her legal skill, she was now widely viewed as one of the most knowledgeable and effective legal thinkers serving in Congress. Young attorneys, especially women of color, began citing her as a powerful example of how public service and uncompromising ethical leadership can work together. But the most significant outcome was the national debate the case sparked about transparency in the judicial branch. A Gallup poll conducted 1 month after the confrontation revealed that 83% of Americans believed federal judges should follow stronger ethics rules and provide more detailed financial reports. 6 months later, bipartisan lawmakers introduced a new bill, the Judicial Financial Transparency Act, which required expanded disclosures and established an independent oversight board for judicial ethics. When the legislation was introduced, the Republican co-sponsor explicitly referenced Crockett's courtroom moment, describing it as a rare event that crossed political lines. The corporate legal world also felt the aftershocks. The Association of Corporate Counsel released new rules warning companies against any communication that could be interpreted as attempting to influence a judge or expecting favorable treatment. Major law firms ran internal audits of their litigation practices to ensure they met ethical standards and avoided anything that could resemble improper influence. 1 year later, a comprehensive Brookings Institution study examined the long-term consequences of the confrontation. The report concluded that the Crockett-Traynor episode marked a turning point in the enforcement of judicial ethics, strengthening public trust that conflicts of interest would be uncovered and corrected. Meanwhile, Judge Traynor's story reached its final chapter when the Fourth Circuit Judicial Council completed its investigation. The council determined that he failed to disclose conflicts in 37 separate cases across 7 years. Rather than face possible impeachment, Judge Traynor announced his retirement. In his public statement, he admitted to serious errors in judgment. He wrote, "Although I have always attempted to uphold high standards of judicial conduct, my failure to disclose certain financial interests damaged the public's trust. Our justice system depends on that trust, and I deeply regret any harm my oversights caused." Perhaps the most powerful reflection came from a first year. law student who had witnessed the entire confrontation from the gallery. In a widely shared essay, she wrote, "What I saw that day wasn't just a legal exchange. It was a lesson in moral courage." Congresswoman Crockett proved that great advocacy is not only about knowing the law, it's about protecting fairness, even when you must stand up to the most powerful people in the room. For millions of Americans frustrated by a system that often seems to protect those in authority, the Crockett trainer confrontation became a rare moment of hope. It showed that preparation, integrity, and courage can expose wrongdoing, challenge entrenched privilege, and remind people that equal justice is still possible. If this story of legal courage and expert advocacy inspired you, make sure to hit the like button and subscribe for more content that highlights how determination and knowledge can hold powerful institutions accountable. And share in the comments which moment from this confrontation stood out to you the most, because when we demand integrity from our institutions, we strengthen our democracy and our own role within it.